course, it's Tuesday, so it is Legal Tuesday. We talk about things that you need to know as an individual when it comes to legal matters. Yesterday, there were two stories on the newspaper of an employee who was dismissed unfairly and was awarded 79 million shillings. And there was also another one who was detained. He refused to go to work on a Saturday, and then he was detained for 42 days. But then the court ruled in his favor, and he was awarded money, I think 8 million thereabout. And so that led us to this conversation, or rather on what understanding your rights as an employee. What does the law say? In studio today, I have an advocate of the High Court. I have Conrad Atiang. Conrad, good morning.
Good morning to you, Angela.
How are you doing?
I'm well, thanks.
So good to have you here today.
Pleasure is all mine.
Yeah.
It's my first time here.
It is.
But it's not also my first time on radio. I've been doing quite a number of interviews. And I'm happy to be here.
Yeah.
Yes.
I'm glad to have you here as well.
Yes.
Conrad, you had a look at the two stories
Yes.
of the gentleman who was detained for 42 days
Yes.
for refusing to work on a Saturday.
Exactly.
And then later on, he got dismissed.
Yes.
And then the other one is an employee, he was a CEO,
Yes.
who was awarded 79 million shillings after unfair dismissal.
Exactly.
Could you speak to these two stories?
I will start with the one for unfair dismissal.
Yeah.
And for a very long time, we've had a contest on what is enough to compensate for unfair dismissal.
Yes.
The one for the CEO. And I think we are moving to a point where we are now consistent on the law that compensation should be at least 12 months salary worth for unfair dismissal. And I think that is what this former CEO got for unfair dismissal. Yeah, so it's progressive to that end, but I am very sure that they might appeal it and contest the reasonableness of that award. Yeah, but for us as practitioners of employment law, we look at it as fairly progressive.
So when you say 12 months, that means that's a year.
That's a whole year.
And so they pay you consistently. They pay you money worth
12 1 year.
1 year.
1 year worth of your salary.
Yeah.
Yes.
Okay.
The jurisprudence we have has been a little bit mixed up in terms of some judicial officers look at it in the sense that compensation should be at least not less than 3 months. Then there are judges that have been awarding one month only. So we look at what is the gravity of the unfairness. When you say that this was unfair and unlawful,
yes,
to what extent was it unfair and unlawful? And how do we then say conclusively that this was indeed so bad? So in the very worst circumstances, then the judge or the magistrate would then now award up to 12 months.
Okay.
Yes.
What qualifies as an unfair dismissal?
Unfair dismissal would ordinarily mean that the principle of fairness was not followed. Remember, anything that is unlawful then becomes unfair. Yeah. And someone would also say that anything that is unfair then is also not lawful. So unfairness come out of the nature of the employment that someone has. And then we look at now, how was the process of termination?
Yeah.
What were the reasons for termination? And if these reasons then are not, how much notice was this person given? Then after that conclusion has been arrived at, then we can now confidently say that the termination of this employment was actually unfair.
Okay. So let's look at employees, and at times I look at it in two different parts, right? And I look at it in terms of redundancy, and then there's also an instance where maybe an employee might feel like I was just sent packing, right? Without notice, right? What should I look out for, even when you're being let go of by an employee? Because at times we do not know, and having this conversation is so that we may be aware of our rights and we know this process that has been followed is unlawful, right? When an employee is being dismissed, what are the things that should be looked into?
first we may want to look at how are employees dismissed.
Okay.
And the first manner of dismissal is where you want to dismiss an employee through a notice, or where the employee themselves want to terminate employment. In fact, as we don't look at it in form of dismissal, because dismissal we associate with the second group of termination of employment, which is summary dismissal, which is then now termination without notice. But the ones with notice then would follow certain tenets. For instance, we look at whether the employee is completely incapable of performing their job, or they were not performing their job according to the standards and the job description as required, or where an employee has been, for instance, has been sick for an unreasonable amount of time, and then it's almost certain that this employee can no longer come back to work. So it's majorly about performance, about the contract, if they are under contract. But the second one is where the employee is now being terminated without a notice. And that for me is where most people fall into the trap, because there is the part of the termination where the law says there are certain things that if you do, then you are to be terminated, or you're likely to be terminated without notice. So that if you come to work drunk, if you insubordinate, if you absent yourself from work without notice for a long period of time, if you are guilty of a criminal offense, or if you are arrested for an offense and you absent yourself for more than 14 days at work, then with that, then the employer has the liberty to terminate you without notice. But there's the problem with this, and this is where most employers fall into the trap, and for us as lawyers, we tend to look at it as good business, is the procedure.
What's the procedure?
Yes.
Talk to me about that.
It's the procedure.
The
moment you have a video of an employee insubordinating, or a picture or evidence, it is enough to terminate that employee without notice. But there are certain things that you must then do to be able to now comply with the procedural bit of that unfair summary dismissal, so that it does not become unfair. Because if you then fall into the trap of not following the procedure, then that termination, despite the fact that you had proof that they had conducted themselves in a manner that qualifies them for summary dismissal, becomes unlawful. So that you need to then now give them a show cause notice, and tell them that they should show cause as to why their employment should not be terminated summarily. So in essence, they're being asked to explain the circumstances surrounding the events that have qualified this this summary dismissal, and then you have to give them a hearing, and most people do not give that. Most employers do not give that hearing. Once you give the hearing, you give them a hearing opportunity to come and explain. The need is normally that it has to have an employee of a similar level to that employee, accompany that employee to that meeting. Or if they belong to a union, then you have to call they can call a member of their union to also come into that meeting. And then now after the hearing of that proceedings, then is when now you can confidently say at this point that this person, we are still going to terminate him either way. That means that the employer or the people who are listening to this grievance are not satisfied with the explanation that they have done. Then automatically at that point you will now terminate their service.
Okay. You've mentioned something. You spoke about an employee who hasn't shown up to work for, let's say, 14 days, and their whereabouts are unknown. In this instance, for an employer, do they have to give, is this when now they start giving a warning letter, or they just don't say that you've not been showing up, so we're done?
Yes. So this one now is not summary dismissal. Remember, there are two absenteeisms. There is this absenteeism that can be explained with leave, but now it is affecting his performance as an employee.
Yeah.
For instance, he's been attending to a sick patient, a parent, but he has now been attending to this parent for more than a month, completely absent from work.
Yeah.
Or he himself or she herself has been sick. So that there is then a period, most employment contracts, and we are going to discuss employment contracts.
Yes.
Most employment contracts and human resource policies and human resource modules normally specifically provide in an organization how long a sick leave should be, then how long a paid sick leave should be.
Yes.
Then at which point do you then now say we have released this employee to remain on sick leave, but it's going to be unpaid.
Yes.
So if then the organization notices that this employee is not coming back, then at that point the employer can issue a notice for termination and say, at this point I don't think that we can continue the engagement. But the other one, where the employee is not coming to work but is also not explaining why he's not coming to work, then that is a ground for summary dismissal.
Okay.
Yeah.
All right. There's so much to unpack there when you say the other one where the employee does not come to work and they don't and they do not explain why they're not coming to work. Still, with this employee, the employer needs to give it's like a show cause letter. Yes. Yeah. And these show cause letters, because I hear people say give the first one and the second one, the third one you're gone.
There is a difference between show cause letter
and a warning letter.
Break
it down.
A warning letter is where this person is making small mistakes. It could be performance mistakes.
Yeah.
For example, he has delayed reports. He was supposed to report by the second week of the month.
Yeah.
For 4 times in a row, they have been reporting on the third week of the month or at the end of the month. And you can clearly see that they are doing it with reckless abandon.
Yes.
Then in that case, you need to issue a warning letter. I'm using that as an example. Then that in those circumstances, maybe you are issuing only a warning letter. Or someone does something that constitutes summary dismissal. Maybe he comes to work drunk. And you look at it and you say, I do not think that his coming to work drunk has affected his job, but it is not acceptable.
Yes.
We do not like the fact that these employees are coming to work drunk, but at least he performed his function. Maybe he's a guard, or maybe he's actually in operations. But you can clearly see that the only issue we had with him that morning was the smell of alcohol. The rest of the other things were performed accurately. So everyone knew he was drunk. So you issue a warning letter. You say, at this point, don't come to work drunk again. We have noted that you actually been coming to work 3 times a week, on Fridays, on Wednesdays, Fridays, and maybe Mondays.
Yeah.
So this is just that the management has noticed, and we are warning you that could actually lead to summary dismissal.
Yes.
So now, if you have issued more than 3 of them, and they are all conduct that are in relation to summary dismissal issues, then you can then go ahead and issue a show cause letter, because you have already given them a chance to change. Remember, warnings are so that you change, giving them an opportunity. Show cause is that you are this close to actually getting terminated, and you are now being given an opportunity to explain why you should not be terminated.
Yes.
That's the difference.
Okay. I just want to wrap up. I'm loving the conversation, because when you say warning letter, so how many warning letters does one need to issue?
There's no maximum number.
So an employer can just issue 1 and then a show cause letter?
Yes.
Okay.
You remember that there's no necessity in the law to issue a warning letter. A warning letter is from a human perspective, and it is from what we call a fairness perspective.
Okay.
Even though for instance, if someone is suffering from alcoholism, And his justification for coming to work drunk has always been, and maybe he has reported to the institution and said that the reason as to why you will always feel the smell of alcohol at work is because I suffer from alcoholism. Then that is to justify, so that if you continue issuing warning letters, it doesn't add value. This person is sick. His drunkardness is because he is actually sick. Does the organization want to continue working with him? Yeah.
All right. Now let's talk about the contract. What makes an employment contract legally valid?
What makes an employment contract legally valid? The way the law looks at it is what establishes an employment relationship. Because when you say what makes it legally valid, then the question would be, was there an employment contract in the first place? So that then, is it valid?
Yeah.
But what we look at mostly, what we focus on mostly to add value to this conversation is that was there really an employment relationship?
Yes.
So that was there an employer? I'm listing down for you the things we look at to validate a contract.
Yes.
And was there an employee? The second thing, so that those are the partners in that contract. The second thing, was there duties and obligations? Was there what an employer should do? Was there what an employee should do? In fact, some say that was there work?
Yeah.
Because if you then give someone an employment contract, but don't supply that work for that employment contract, then the main question is, was there an established employment relationship in the absence of that work? Then now we break down to smaller issues. What were the terms of that employment? What were the job description? What were the duties of the employee? What were the employment terms in terms of remuneration, money? What are the consideration financially, benefits that this employee is entitled to by the virtue of being employed? What are the working hours? For how long should he work?
Okay. I want to take you back to... You started with, was there a contract in the first place? So there are two things. There are instances where we have an employer, we have an employee. There's work, right? You're offering a service. However, there's no legally binding document. And I think this is where now the contract comes in place. If we've had a scenario where this person has been offering a service and this person has been paying for the said service for a period of a year, 6 months, a year. Do we say that there's an employment relationship?
Exactly. And that's why I said the main focus we should all have is there an employment relationship? And that does not need to be in writing. So that if we are able to establish that this person used to call someone Mdosi, and for 6 months he would pop into his office with a cup of tea and he would put it on his desk, and at the end of the week he would be paid, even if it is 1,200 or 2,400. And remember, at this point we may want to discuss what is a casual employment and now a contractual employment, which is probably more organized. Casual employees, and most people associate casual employees with casual laborers. So that if you tell someone that they are a casual, they assume that a casual employee is only a laborer. Maybe people who sweep, people who lift heavy. But you can be a casual employee in a very serious establishment. Like I know of counties that have casual employees in audit, in finance, in HR. Casual employee simply means that your payment is not on a monthly basis, and where it is on a monthly basis, then the law says that if it is paid consistently in that manner for beyond 3 months,
Beyond 3 months, yeah.
yes, then that employment relationship, whether it is in writing or not, is no longer a casual employment.
Really?
So then there is an established contractual relationship between the employer and the employee.
So what you're saying is, for this casual employee, if you've been a casual employee for 3 months, you need to now graduate to...
You graduate automatically, but you don't need to.
You graduate to what now?
You are now employed under a contract. Consistently, the court will look at, or the law looks at, were you being paid consistently? Did this present a semblance of a job that you wake up and report to on a daily basis? And if you so did on a daily basis beyond 3 months, then your contract is not casual. Remember, casual employment, the termination notice is in terms of how you are paid. Let's break it down a little bit and look at who is the most common casual employee.
Yeah.
And that is people who work in construction sites, people who work in godowns, people who work in yards, people who wake up not knowing whether they are going to work. And then they report somewhere, and then they are going to be handpicked in EPZs, in godowns, in shipyards, casual, as we know them. People work in construction site, watu wa mjengo. So that if they go to this place every day, they will be paid on Friday or on Saturday morning. And if they are paid on Saturday, that's the end of their employment. They need to report again on Monday. And if they don't report, they are not employees of that person. That's the nature of casual employment. So that if you do this for 3 months, because casual means that we are giving you a temporary opportunity to finish a particular job.
Yeah.
So if it is this building, I can't build this thing for 9 months. I have a deadline of 3 months.
Yeah.
I need to hand over the keys after 3 months or after 2 months. The law looks at it in the sense that casual employment was never intended to exceed 3 months.
Okay.
So that if it then exceeds, then you need this employee. So if you don't employ them now formally, the law automatically employs them formally.
Okay. So for an employee who's had, and I know a lot of people, you're right about people who've been in that space of, I'm a casual, and you've been there for a year, 2 years.
Yes.
What should they do? And also speak to this person who's been there. What should they do? And also to an employer, what are some of the gaps that employers allow that leave them vulnerable?
That expose them.
Yes.
Okay. To the employee that has been employed on a casual basis beyond 3 months, I think all I could leave them is with the knowledge that they are no longer casual employees.
Okay.
That they have rights and that they should now start to be entitled to other benefits that employees should gain who are on contractual engagements. For instance, they are entitled to things such as SHA. They're entitled to NSSF, the Social Security. They are now entitled to leave days if they have gone beyond a year.
Yeah.
It doesn't matter whether there's a written contract or not, provided that they have worked for 12 months and they are continuing to work.
But there's no written contract.
Yes. They are entitled to leave. There's no written contract, but there is a predictable, systematic employment engagement between the employee and this employer.
Okay. Before you answer to the things that employers do that leave them vulnerable, I really want to finish up on the contract.
Mm.
When we talk about what risk, or rather, what am I exposing myself to being in a space where I do not have a contract? And I've been there for a year, 2 years, 3 years, 4 years.
The disadvantage you have without a contract, for me, is there is no clarity of terms.
Mm-hmm.
When you say I'm entitled to leave days, you may only be entitled to what the law provides.
Yeah.
When you say you are entitled to overtime, we may not be able to account for how much overtime you have. When you say you are entitled to certain benefits, insurance, health insurance,
Mm-hmm.
then it becomes a challenge for us to now say, to what extent is this benefit in the absence of a contract? The contract normally makes it easier for us to understand what were the terms. So that when you say that this was not within my job,
Mm-hmm.
for example, you come to Swahili Pot as a presenter.
Yeah.
In the course of your engagement, they add responsibilities. They give you something else, social media marketing. In the absence of a contract, then we do not know how to handle this new additional work. We do not know how much you should benefit from it. In the absence of a contract, we do not know how to treat your overtimes. If you're working hours, you come to work and no one specifies how much time you should work. Or you should work from 6 to 10 in the morning show. And then, sorry, I'm using this as an example. It could be bad.
Go ahead.
But and then now they tell you, stay a bit and do for us 3 o'clock show, the drive up to another 7 p.m.
Yeah.
And now you're definitely wondering, what should I then do in the absence of a contract?
Mm-hmm.
Then you're putting yourself in a very difficult situation to understand how you should handle the employer additional responsibilities or additional engagements. Yeah.
Okay. Shouldn't that okay, so that's not for somebody who does not have a contract, right?
Yeah.
Let's look at what an employee should look out for before signing a contract. You're about to sign a contract.
Yes.
It's been presented before you.
Mm-hmm.
What are the red flags that employees should watch out for before signing a contract?
I would not think there are red flags.
Really?
Yes. I would.
Why?
Because
I have one.
Because the way we look at contracts generally, and this is not only applying to employment, is that if someone creates a contract that is negative against someone's expectations or obligations in the contract, and then it is found that it was actually those terms were unfair, then the interpretation of that unfairness should be to the disadvantage of the person that created the contract.
That's not to the employer.
Now that is to the employer.
Okay.
So most employees would not want to do that. But what should they look at? The little details. As long as we say the devil hides in the details.
Mm-hmm.
The little details would be something as much as how much liberty does this person have? Does it clearly specify how much working hours should he engage in?
Mm-hmm.
Most things that employers and employees conflict over is time and money.
Mm-hmm.
They say time is money.
Yep.
So it's both. So that if then I should work between 8 to 5, then I am at liberty to leave. If I should not work, and I'm going to discuss the second case which you forgot to ask me about.
Yes.
If I should then now work up to Friday only, how do we treat working on Saturday?
Saturday. Yeah. Or Sunday.
Or Sunday.
Yeah. That's like 6 times a week.
Yes. So if I work on Sundays, then should I be compensated fairly for it? And if I am not compensated for it, what is my remedy? So these are supposed to be things that you could clearly see in the contract.
Yes.
And if they are missing, then it is easy for you to say that this contract by itself is a red flag.
Mm-hmm. All right. There's a clause that's usually in the contract.
Yes.
And any other role.
Any other role.
Yeah.
It is very ambiguous,
Mm-hmm.
so wide and vague that I may not think that it is fair on the part of the employee to just accept any other role as may be assigned by your supervisor.
Yes.
That's the term.
That is the term.
Any other role as may be assigned by your supervisor. Well, but within the scope of your job description. So that if you are coming to this workplace as a technician,
Yes.
then it should be any other role being assigned as a technician, but within your knowledge as a technician.
Yeah, within your job description.
Within your job description.
Yes.
So it may not just be written down, but it actually emanates out of some jobs. Come up with situations, and the employer looks at it and says, who could do this in this organization?
Mm-hmm.
Who could come up with ICT policies? Formulation of policies in the organization belongs to HR.
Mm-hmm.
But we look at this and we say, does the HR have the knowledge to formulate policies on ICT?
Oh.
Do they understand it? But in the original agreement for employment, it was not there. So the employer says, then let's assign so and so to come up with these policies, because I think he understands it better than anyone else. So this is any other role as may be assigned by your supervisor. But if you see an ICT personnel being told, now tomorrow Wafula is not coming, or Simiyu is not coming, or Onyango is not coming, and now the gate will be unmanned, so we wanted you to maybe, is it possible for you to sit at the gate? Now that is not any other role as may be assigned. This employee can contest and say that this was not part of my job description.
Yeah.
Yeah.
Okay. Working hours now. And we've touched on it, because most times, and I don't think it's very specific. At times, when even during your interview, you're told, okay, Monday to Friday, 8 to 5, right? But then the instances as you get in, I remember this so well in a certain organization. As I got in, then a weekend role was introduced, right? But that wasn't there, and you see, there was a bit of protest. This was not there. We do not want, and I wasn't just the only person who was protesting. The other people who were also saying, this was not there. This is not what I agreed to. But you know what? We ended up actually doing it. So how should this be stated clearly? Like, what does the law say about working hours? And is it automatic that the working hours, if you work an extra day, should it come with overtime? Is that even overtime?
I think it is overtime.
Yeah.
It is overtime because if your contract stipulates that you will work up to Saturday or half day on Saturday, that is your contract. If you sign it, you're bound by it.
Yeah.
But if your contract specifically says that you work up to Friday, Monday to Friday, then working on a Saturday is completely outside your working hours. It automatically becomes overtime. And you should be compensated in the nature of an overtime. You should claim for it. Most employees are afraid to claim for their overtime.
Yeah.
Because maybe they fear to be terminated. But I think that if your fear is to be terminated at the point of working, or of when you are still working, when you claim it, document it. Document it.
Yeah.
Wait for the time of your separation with this organization. Claim it as part of your dues, terminal dues, and say, on this month, I worked 6 days every week for 4 months. So I have I have 4 extra days that I need to be paid for as part of your terminal dues.
Yeah.
Yeah. But I think that all employers and employees should actually put their heads together and agree on whether or not, if the contract had specifically specified the working hours, any form of changes into the contract should be by consensus between the employers and their employees.
Yeah.
So that you cannot just out of the blues wake up and say that I think from this month we are going to start working on Saturdays full day. Then that is an unfair labor practice. Yeah.
And so you can contest.
That one you can contest. You can contest in court. I normally tell employees that you can contest while working there.
But how? That's not even healthy.
Completely not healthy.
Yeah.
But it is actually legal.
Yeah.
Because you can contest to achieve a fair labor practice within the organization.
Yeah.
The only disadvantage is it might end up in termination. And if it ends up in termination, then it will also be victimization. So you'll be terminated because you protested a particular labor issue within the organization.
Yeah.
And that people have been awarded compensation for that type of victimization. Look at it in the sense of working in a big organization such as the county government or Department of Health in the county government. And an unfair labor practice is being introduced within that department of the county.
Yeah.
And you're one employee, probably without a union. What should you do? I think you should contest while working in that organization.
Yeah.
Yeah. And most government institutions will not terminate you for protesting. They will just make changes. They might transfer you to another department.
Yeah.
Yeah. Again, if that transfer is not justified,
You can still contest.
contest.
Okay, then. Now let's look at what employers do that leave them vulnerable.
That leave them vulnerable.
Yeah.
Most employers have lawyers.
Okay.
So the advantage they have is they rarely do. But one of the things that I would think leave them vulnerable are actually two things. Number one is engaging people in a casual engagement for far too long.
Okay.
And assuming that terminating them would be easier. Oh, because I pay you every week. I know of someone who employed gardeners for 22 years. Here in Mtwapa, not so far.
22 years.
Yes. From 201, some from 99.
Oh.
They were terminated this year. And they were terminated this year in the nature of casual employees.
Oh.
These people have been paid on Friday for the past 21 years.
Yeah.
Now that, most people take it so easily and they assume that this person is actually a casual employee.
Yeah.
But no, they are not. The other practice that exposes employers the most in here in the coast, and I want to be specific to the coast, are contracts. Coast from the coastline, Lamu, Malindi, Kilifi, have hotels, beach resorts, and most employees in those engagements are on a 3-month contracts. And towards the end of every 3 months,
it's renewed.
They renew.
Yeah.
So someone has been an employee for the past 9 or 10 years in a beach resort as a barman or as a housekeeper.
Yeah.
For the past 11 years on 3-month contracts. Somewhere there will always be a mistake. Yeah.
What's the
because
risk with that?
At the end of a year, they will start giving leave days. Yet you're saying this person is employed on contract basis.
Yeah.
And if this contract expires, I am at liberty not to renew it. But yet you gave this person a whole month of leave last year.
Yeah.
You gave him leave again the year before and the year before. So while you are hiding in the comfort of the 3 months contract, assuming that if this 3 months contract end, this employment will terminate automatically, then you are also performing other obligations of long-term contracts, such as you have enrolled them for NSSF, right?
Yes.
You have enrolled them for NHIF and you have consistently paid. In fact, you have a standing order for it. That every month, pay so and so, pay so and so.
Mm-hmm.
You're even giving them loans. So your engagement is not actually 3 months. Someone has a loan for that he needs to pay for the next 48 months. Yet he has a 3 months contract in that organization.
Mm-hmm.
Yet he was guaranteed by that employer. So those are the dangers that some employers actually do not know when they're entering these engagements with employees.
All right.
Yeah.
Thank you so much, Conrad. There's so much to unpack. I know we've just scratched the surface. Yeah. Thank you for making time today.
Thank you.
Yes, we have been speaking to Conrad Atiang. Of course, he's an advocate of the High Court, looking at what you need to know as an employee, your rights as an employee, so that we may stop being ignorant, And I think right now you know what to do if you find yourself in a situation whereby you've been somewhere and working